Hi guys, this is Piyush from Finco Technological Solutions, a web-based Nidhi software providing company. Today we will be going into details of the most important topic related to Nidhi companies, which is how to reply to show cause notice in case it is received from ROC. Guys, this is part 1 of the total video. As the video is an elongated one and a long one, we have broken the total observations which MCA can raise into a number of parts. This is part 1 of how to reply to show cause notice or notice for inquiry received from ROC. Before going into details of in which case scenarios when MCA can issue notice for inquiry to Nidhi Company, let me tell you a Nidhi Company is governed by both Companies Act 2013 as well as Nidhi Rules 2014 along with any amendments made thereto. A Nidhi Company is strictly required to compare and adhere to ROC compliance rules related to Nidhi Company. The ROC compliance is basically providing details of the Nidhi's financials, the members, the deposits, the loans to the ROC on a timely basis. Now, when can this notice been issued is divided into two categories. One, the notice is received due to non-compliance with Nidhi rules on a timely basis, and secondly, non-compliance or compliance made within timelines but with wrong data. In either case of non-compliance or compliance made with wrong data, the stakeholder of Nidhi companies, the owners of Nidhi companies and the consultants of Nidhi companies can be levied with heavy penalties and notices, piles of notices. We will now move to list of observations which the ROC can issue to Nidhi companies. One such observation is non-compliance of Section 139 subsection 1 of the Companies Act 2013, which requires a company to inform the ROC about appointment of auditor in Form ADT 1 within 30 days from the conclusion of first AGM. Let me take you to the observation which one of the Nidhi companies has received from ROC. It stated as, it has been found that the company has defaulted in filing of notice of appointment of auditor in Form ADT 1 with the Registrar of Companies within due time from the conclusion of first AGM, which leads to violation of Section 139 subsection 1 of the Companies Act 2013. We will deal with these observations in two manners. One is, first we will be discussing the provisions of Companies Act or Nidhi rules related to this notice, and thereafter we will go into the reply or submission which a Nidhi company should provide to ROC. The provisions of Companies Act 2013 says that once an auditor is appointed in an AGM, the notice therefore in Form ADT 1 needs to be filed with the ROC within 15 days of such meeting. The company is eligible to appoint an individual or a firm as an auditor, and that person or the firm is eligible to be appointed as an auditor till the conclusion of 6th AGM. Now coming to what is the reply or submission that the Nidhi company needs to make in case it receives this observation. Guys, if this is the first year of the Nidhi's operation, the company needs to mention to the ROC that first auditor is appointed by the company's board of directors within 30 days of incorporation in its board meeting. Guys, if you see the requirement to file ADT 1 is only in case the appointment of auditor has been made in AGM. The Act the rule, both are silent on as to what if the auditor is appointed in a board meeting and not in an AGM. As because the act is silent on that, we can take the benefit of that, and we can mention that as the auditor has been appointed in the board meeting and not in AGM, the company has not filed the ADT1 with ROC. But what if the letter from ROC is received in its second year or subsequent year of company's operation? In such a case, the management needs to accept the mistake of not filing the ADT1 within timelines, and it needs to file this form ADT1 along with additional fees and mention the SRN number with the date in its reply. The copy of SRN needs to be attached as well for the reference of ROC. Before we move to the second observation pointed out by MCA, I would like to mention that the software features, the FinCode Nidhi software features have been mentioned in the bottom right corner, and in case you are willing to use or take up a new software, I would like to suggest FinCode Nidhi software to be taken up as it complies with all the regulations of ROC. The second observation pointed out by ROC is related to non-compliance of Section 92 subsection 3 of Companies Act 2013 and Rule 12 of Companies Management and Administration Rule 2014. Now what about this observation of ROC? See, as a Nidhi company ROC compliance, we are required to file AOC 4 and MGT 7 with ROC on a yearly basis. When we are filing AOC 4 with the ROC, we are required to provide director's report or board's report as an attachment to AOC 4. The claim of ROC is that in the board's report or in the director's report, when we are submitting an ROC to ROC, the company is required to attach an extract of annual return in form MGT9 with the board's report. Let me take you through the observation which one of the Nidhi companies has received from ROC. Upon examination of board's report as on 31st March 19, been found that the company has failed to attach an extract of annual return in form MGT9 with the board's report as per the provisions of Companies Act 2013. Therefore, the company has contravened the provisions of Section 92 subsection 3 of the Companies Act 2013, read with Rule 12 of the Companies Management and Administration Rules 2014. Coming to the provisions of Companies Act and Nidhi rules, this observation will be dealt with under Section 92 subsection of 3 of Companies Act 2013, Section 134 subsection 3 of Companies Act 2013 and Rule 12 subrule 1 of Companies Management and Administration Rules 2014, which requires the extract of AGM annual return to be attached with board's director's report in form MGT9. In the reply to this observation made by ROC, guys, we need to refer to Section 134 subsection 3 of Companies Act 2013, which is the governing section of Section 92 under which the observation has been pointed out by the ROC. Guys, we would like to bring to your attention that the provision of Section 134 subsection 3 has been amended by Companies Amendment Act 2017 via notification dated 31st July 2017, which states that MGT9 has been removed from Section 134 and a new provision has been added which states that the web address needs to be provided where the annual return has been placed. So as because this section has been removed via Companies Amendment Act 2017, the ROC cannot provide a inquiry or provide an observation on a section which does not itself exist or which has been replaced by the requirement of filing of annual return in the web portal of the company. But the Nidhi company must need to ensure that the annual return has been uploaded in the web portal. Guys, the word to word reply or submission which is required to be made against this observation of ROC has been mentioned over here, and the same can be submitted to ROC in case your Nidhi company receives such an observation. Moving to next observation provided by ROC related to non-compliance of Rule 14 of Nidhi Rules 2014, which this observation is basically on non-maintenance of sufficient amount of unencumbered term deposit with any scheduled commercial bank. The observation that was pointed out by the Nidhi Company ROC is upon perusal of balance sheet for the financial year ended 31st March 19, it has been noticed that the company has outstanding deposits amounting to 2 lakhs, which is inclusive of fixed deposits, savings account, recurring deposits and so on. However, the unencumbered term deposits is showing deposits of 5,000 only, which is below the limit as specified in Nidhi rules. Directly going to the provisions of Nidhi rules as regards this observation, the requirement says that the Nidhi company is required to maintain 10% of total deposits outstanding at the close of business on the last working day of the second preceding month with a scheduled commercial bank. Now, what does this mean? This basically means for a Nidhi company, of the total deposits that the Nidhi company has on 28th of February, of that total deposits, 10% of that total deposit needs to be submitted in a term deposit, in a fixed deposit with any scheduled commercial bank. This is a requirement of Nidhi rules. Now, what if the amount of deposit in unencumbered term deposit maintained with scheduled commercial bank is not 10% of total deposits received by the company as on that specific date? In such a case, the general parlance is to accept the mistake on grounds of not being aware of the said provisions. However, the company has got one more option, like in case it is not having 10% of total deposits under unencumbered term deposits, but it is having certain amount of term deposit which is maybe 2% or 4% or 6%, 7%, whatever, the company can claim that majority of the deposits available with the company were created in the last month of March. See, this is basically a loophole. In case the amount of total deposits, majority of total deposits has been received in the month of March, the deposits outstanding on February end will be a substantially low amount. We need to make sure that we have a term deposit of at least 10% of that low amount as on February end. If we can provide and prove that claim of ours, we can avoid unnecessary penalties or unnecessary notices from ROC. The next observation pointed out by ROC is regards to violation of Rule 8 Sub-Rule 1 of Nidhi Rules 2014. Now, what does this rule states? This rule requires that a Nidhi company can have as its members only individuals. Non-individuals like a body corporate, like a company, like an LLP, like a partnership firm cannot be a member of a Nidhi company. This is what MCA found out, ROC found out from the MGT 7 that was submitted with the ROC as an attachment to that membership details are being submitted. Once again, I will tell you that as a attachment to MGT7, list of shareholders is being attached. From there, the ROC has scrutinized the data and found out that one of the non-individuals has been admitted as a member in the company. Guys, if you remember, in the very start of this video, I had mentioned to you guys that not only timely compliance is important, but also compliance with correct data is required. Now, ideally, in a scenario where the software which you are using is a correct one, if that being a correct one, the software would not have allowed the non-individual to be admitted as a member. But unfortunately, most of the softwares in the market are not as good as FinCode Nidhi software and does not provide as much automations, validations and checks as the software provided by FinCode Technology Solutions do provide. Coming to the observation that one of the Nidhi companies got from ROC, it stated as, upon careful examination of list of shareholders attached with MGT7 as on 31st March 2019, it has been found that the company has admitted a non-individual as a member in the company, which is not allowed in Nidhi rules. Therefore, the company has violated Rule 8, Sub-Rule 1 of Nidhi Rules 2014. Though this observation is a clear-cut indication that as a company, the Nidhi owners have not been able to understand the provisions correctly and neither the software is capable enough, the only option that can be provided to ROC in its reply is by stating that the non-individual whose name was mentioned in the shareholders list is basically an authorized representative of an individual who has been admitted as a member. Now, as that individual was not capable of signing the documents, by mistake, the authorized representative who signed the documents on his behalf, his name has been mentioned in the list of shareholders. By that submission, we may get away from this observation of ROC and we may be not required to pay penalties or hefty amounts against these observations. Coming to next observation of ROC, which is on account of violation of Rules 5 Sub-Rule 2 of Nidhi Rules 2014, the requirement of filing NDH1 and NDH3 on annual/half-yearly basis has not been met with by the Nidhi Company. Going through the observation pointed out by MCA to one of the Nidhi companies, it stated that as per the records available at MCA portal, the company was incorporated in the financial year 1819. Thereby, the first financial year of the company ended on 31st March 19. However, it has been noticed that the company has not filed NDH1 from the closure of first financial year as specified in Nidhi rules and NDH3 during the half years ended 31st March 19. Therefore, it is submitted that the company has defaulted in filing NDH1 and NDH3 within due dates, which leads to violation of Rule 5 Sub-Rule 2 of Nidhi Rules 2014. Before I go into the details on what submission should be made by the Nidhi Company against this observation of MCA, I am not able to understand why the consultants or why the Nidhi Company owners are not submitting the form NDH3 and 1. On inquiry, I found out that most of the owners come up and say that they don't have the requisite data to file NDH3 and NDH1. See, the basic requirement of a software is to process the transactions and provide automated reports. Now, if your software is not able to provide the automated NDH3 form or NDH1 form, it is really outdated. You need to update your software, like FinCode Nidhi Software, which provides up to date and automated NDH1 and NDH3 forms, which you can directly download and upload to the portal. Coming to the provisions of Companies Act or Nidhi rules, every Nidhi company is required to file within 90 days from the close of the first financial year a form called NDH1, and within 30 days from the close of the financial year a form called NDH3 with the ROC. And this is a very important form and specific only to Nidhi companies. Guys, remember that a normal private limited company or normal public limited company is not required to file NDH3 form and NDH1. It is only related to Nidhi companies. And as part of submission, the only option which the management has is to file the form NDH3 and NDH1 by paying the additional fees, also called as late fine, and submit it to the MCA as soon as possible, and if possible before submitting the reply to the ROC. Before submitting the reply to ROC, the company should file NDH3 and NDH1 with whatever penalty additional fees that is coming, and mention the SRN number along with the date of filing of such form in such reply. Also, the copy of SRN challan needs to be attached along with the reply. Guys, I won't be making this web server, web software marketing or such, but I do feel that this software provided by FinCode Technological Solutions for Nidhi Company is at least 90 to 95% foolproof and provides you with the requisite data. Also, in case you feel that any observation that has been pointed to your Nidhi company has not been covered in this video of ours, then please move forward and look to part 2 of our video on this same topic, how to reply to show cause notices or inquiry received from MCA. Let me tell you, there are more than 10 more observations that and different kind of observations that Nidhi companies have received over the past, and we have tried to provide you each and every best possible answers to the queries that has been received by Nidhi companies. Do look into part 2 of our Nidhi Software's video. You can search it on the YouTube itself. For the moment, thank you, and let me show you the features which the Nidhi FinCode technological software providers are providing. Just a brief idea that irrespective of the packages you are choosing, you are getting automatic EMI deduction facility, you are getting ROC related reports automatically available, the software is cloud based, you are getting different number of branches depending on the package you are choosing, you are getting almost unlimited admin and employee logins. The help desk support is also very important for any software which is available 24/7 for gold and platinum packages. You are getting SMS and mail notifications. You are getting access to 200 or 500 or unlimited member additions depending on the packages you are choosing. The server space given is 2 GB, 4 GB, 8 GB depending on the package you are choosing. You are most importantly, you are getting my free consultation over phone in case you take this software. Thereafter, you are getting website development access, the customer portal you are getting, the data migration is also available. What is data migration? Basically, in case you are having any outdated software or having any other software and you wish to move to FinCode Technological Solutions software, that is also possible with FTS. The prices has also been mentioned: 2500, 3500 and 5000 are the monthly prices, which is basically the maintenance cost, and one time installation charges is 30,000 each only. Thank you guys. Look forward to part 2 of this video.